Now we're at the bonus round. Specific questions. Whether or how the NLRB should provide assistance to unrepresented local unions in complying with election procedures. Gina Cooper. And then whether or how the NLRB should provide assistance to unrepresented small businesses in compliance with election procedures, Elizabeth Molito. And whether the procedure used by the board in this rulemaking demonstrates that the board values the comments of the public. Kurt Kirschner. Whether the petition bar to election should be changed from 6 months to 12 months if the petition is withdrawn shortly before the election. Joseph Torres. And finally, whether non-parties should be served with board filings. J. Aloysius Hogan. Okay. Ms. Cooper, please proceed.
Thank you. Well, once again, thank you for allowing me to be here to speak with all of you today. My name is Gina Cooper, and I am still the Director of Organizing for the Industrial and Professional Industries of the International Brotherhood of Electrical Workers, AFL-CIO. When I testified yesterday, I addressed the 63% union win number and talked about how little that number meant in reality. Today, I'd like to address another number, which is the percentage of time that the parties enter into a stipulated or consent election agreement, which is done in 90% of the cases. As a very experienced organizer, I know that that number does not necessarily prove that the process is balanced or fair. In my experience, employers wield as much power in these negotiations as they wield in an actual hearing. Again, the threat of delay and mounting expenses from prolonged hearing pressures many petitioners into agreeing to almost anything to get to a timely election. Delay, as I testified yesterday, always works against the petitioner. And the expense of lengthy proceedings also puts added pressure on the petitioner to agree to inappropriate units. For example, many petitioners cannot afford to have an attorney present throughout a lengthy hearing, and local unions often cannot even afford the cost of a transcript. Here are just two examples of these time and expense pressures on petitioners in the negotiation process. First, in El Super case, the petitioner, under pressure from the employer, recently agreed to include supervisors in the unit just to get to a timely election. And in the 2010 BG&E case, the employer threatened its employees that it would drag the hearing out for over a year. After 10 weeks of aimless hearing, the IBEW reluctantly agreed to a unit that was virtually a wall-to-wall unit. The IBEW had initially sought a production and maintenance unit, a unit that is presumptively appropriate in the utility industry. So I do have substantial reason to be skeptical of what the 90% figure really stands for. I was also asked yesterday how the board could improve processes. So I brought a couple of suggestions along today.
Thank you.
You're welcome. First, the IBEW believes that the board could diminish employer domination of our case proceedings by taking control of the process. Accordingly, we recommend that the board take an active role in this fact-finding process. Thus, the hearing officer could subpoena witnesses and documents and question witnesses on the appropriateness of the petition for unit. The parties can cross-examine the witnesses after the hearing officer questions them. But the employer would not control the proceedings as it does now by presenting the case against the petition for unit from the start. If it appears appropriate after the hearing officers and the parties questioning, the employer's case against the unit could be deferred until after the election and its due process rights therefore preserved. Additionally, the hearing officer could also preside over the negotiation process. He or she could insist that the employer present legitimate proposals to alter the petition for unit. He or she could prevent the employer from dragging out the process by pretending to consider the petitioner's proposals during lengthy breaks, only to return and reject them. The hearing officer could also cut short any employer attempt to include inappropriate employees such as supervisors into the unit. Second, the IBEW also proposes the board help cut the costs of hearings to petitioners who cannot afford them. One way the board could do this would be to renegotiate agreements with reporting services. As we detailed in our written comments, transcript costs of $1.95 per page add up rapidly to $12,000 in one case and $20,000 to $30,000 in a couple of others. Thus, we ask that the board negotiate a reporting service agreement that would permit it to provide a free copy of the transcript to any unrepresented petitioner who can attest that it cannot otherwise afford a copy of the transcript. We feel these measures could help in creating a fair and balanced election process. Thank you.
Does that last suggestion presume post-hearing briefing, or are you suggesting, because that's another part of the proposed rule, or are you suggesting that we provide the transcripts just so that the local union would have a copy of the record?
For post-briefing, please.
Okay.
It sort of seems like your proposal breaks down, or your suggestions break down to two categories. One is stop employers from doing inappropriate things, and the other is please. And the other is some sort of financial aid, please, for petitioning unions that don't have legal advice. They don't have anything along those lines. They don't have enough money to pay for the transcript. Obviously, as a neutral government agency, we can't start giving legal advice and be aligning ourselves with any particular party. What I would be interested in is, to the extent that there are IBEW locals that you would know of, or other unions that you would know of, what exactly sort of the Equal Access to Representation Justice Act proposal would look like. Would somebody have to attest at the beginning of a representation hearing or process? Essentially, this union is indigent, it's independent. We're not affiliated with an international, and then the transcript would be free, or I don't know what exactly financial component of this you're talking about. That's one thing. And the second thing is, I don't know, do you know we have an app?
We have an app for that?
Yes, we have an app, and so there is a lot on here about the National Labor Relations Act that I have been told by various parties is of immense value to understanding how the law works and things. I don't think it goes down to the granular level of covering stipulated election agreements, but it's certainly something that any party, be there a small employer or a small union, can avail themselves of, that the agency already has. To the extent that we need to have better materials on the website, this doesn't have to be subject to the public comment process. You can certainly send a letter, for example, saying, can't you address X, Y, and Z on there? And that's free. All that stuff is freely accessible. Vis-a-vis the financial aid piece, obviously in this sort of venue, we can't discuss that. That's probably would be the subject of, there's no part of the NPRM, I think, that even addresses that. But I can certainly talk it over with my colleagues, but I would need to know more of a concrete proposal in terms of what you're thinking about.
We would not be opposed if a copy of the transcript was provided to both parties equally.
Okay.
But I take it that your point is that there is an inherent disadvantage where you have like a union that may be not affiliated with an international, may be a independent union started at a plant, having to try to manage a representation proceeding oftentimes, and I have experienced that, not represented by counsel.
Absolutely.
I see.
When your suggestion about having the hearing officer monitor the STIP discussions, how exactly do you envision that would work?
Well, I do believe that the hearing officer in the pre-hearing could certainly subpoena the witnesses. It would certainly keep things on a more neutral basis. They could subpoena the witnesses, they could ask the questions, and of course, both parties would then have the right to cross and talk back and forth and ask questions afterwards. Right now, as it sits, the company has control over that process, and we just think it would be a much more fair process to the workers to be able to have the neutral party be the one that's talking through the unit.
And I really think I understood that, but the part about having the hearing officer monitor the discussions around the STIP, how would that work?
Well, I think I would leave that to the board to decide, but I do think that having the initial conversations where they were not talking directly, but they were talking through the hearing officer, and that the hearing officer would require them to give concrete proposals back on unit identification would be very helpful in this situation.
Okay. I understand. Thank you.
Okay. Thank you very much.